All right, who are the parties on Christian Gomez? All right, if you come forward. All right, court is calling 2023 CR 0218 State of Texas versus Christian Gomez. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Mr. Gomez.
Are you Mr. Gomez?
Yes, Your Honor.
All right, counsel, have you received all the discovery and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Gomez, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your
State, are you proceeding on the indictment as presented?
Honor. Yes, Your Honor.
Showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1 gram to 4 grams? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Gomez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, your fine is set at $600. The state recommends community supervision and deferred adjudication. This will run concurrent with County Court Cause number 6999123. State will take in consideration County Court Cause number 700-330. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Next, I'm showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
There are not.
Next, I'm showing you outside the plea bargaining agreement. The state is recommending that your community supervision be for a term of 3 years. There be a TAP evaluation, 150 hours community service restitution, no contact with Kayla Benavides and Robert Trevino. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offers State Exhibit 1 in all attachments.
Any objections? All
No objection.
right, you may be excused. Mr. Gomez, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, just ask if the court follows the agreement.
All right, how old are you?
21 years old now.
Do you have any children?
Oh, man.
Are you employed? What do you do?
I work at a tire shop
Who do you live with?
with my father.
Any other children in the household?
Yes, I have 2 younger siblings.
What are their ages?
2 years old and 10 years old.
All right, if you're drug tested today, what are the results going to be? And before you answer, know that you're going to get drug tested today.
Yes, ma'am. This marijuana.
Anything else?
Yes.
When's the last time you used meth?
Um,
All right, well, you had meth in the car. You're going to get drug tested today.
I never used it.
Okay, you're going to get drug tested today, okay? All right, this is what the court is going to do. Court is going to sentence you to 3 years deferred adjudication. There's a $600 fine that will be probated. How far did you go in school?
Graduated.
All right, what are you planning on doing with the rest of your life?
Well, right now I'm working on getting a barber's license now. And that's what I'm heading towards right now.
Okay. Concurrent with cause number 699123, taking in consideration County Court cause number 700330. 150 hours community service restitution. There's to be no contact with Kayla Benavides and Robert Trevino. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. I'm going to want 90 sober meetings in 90 days. I want him drug tested today and I want to test for levels. And then thereafter to be random UAs. There's to be no unsupervised contact with minors. So what that means is you're not allowed to be babysitting the 2-year-old and the 10-year-old. There always has to be another adult in the household. You understand? A responsible adult. So not your friends or anything of that nature. You understand?
Yes, Your Honor.
There's to be regular reporting by Zoom or in person. And I'm going to want field visits 1 time per month until further notice, and probation. If you want to count the field visits as his reporting, you can. And I'm going to want TAP evaluation and follow the recommendations of the TAP. If the TAP recommends inpatient treatment, we'll start with outpatient treatment. If it just recommends outpatient treatment, we'll just do the supportive outpatient. Probation, is there anything else he needs? Is there anything else that you need from the court in order to be successful? All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. You're 21 years old. You've just caused some problems in your life that didn't need to be there. But you can still do better. It's not the end of the world, but you're going to have to start making better decisions. Otherwise, you may find yourself in prison. So from here on out, everything that you do, you need to ask yourself, is this something that could result in me potentially being revoked and going to prison for 10 years? You understand? All right, good luck to you.
Thank you.
And thanks for dressing appropriately for court.
Thank you.
Who's here on Roger Salcedo?
I'm here, Your Honor.
All right, state what is happening with this case. You're supposed to contact the complainant. And you're on that side.
This time on violence?
It's
Jason, I was told when I gave the case file to Jason Barahan, what you understand is.
okay. All right. So what we're going to do is we're going to recall this for Thursday. Ms. Ferguson, on Salcedo, it's coming back on Thursday. So that will be on the 30th.
Your Honor, maybe the excuse.
Oh, yes, after he signs the reset form. And thank you for dressing appropriately for court.
Judge, what were the notes, the judge's notes on this one?
The state was to contact the complainant. All right. Angelina Hernandez.
We're here, Your Honor.
All right, state, what's happening on this case?
Your Honor, this is a newly indicted case. I've spoken with counsel regarding this case. There are EMS records and medical records of this complaining witness that the state does not have in possession yet. So we're asking for a 2-week reset to get those records and review those records to determine our position.
All right, Ms. Ferguson on Angelina Hernandez. If you reset this for 3 weeks, is that enough time for 2 weeks, Ms. Ferguson?
In order, if there's not a bond set on this case, if we approach to get a bond set.
Yes, file the motion and the court will hear it. All right, Ms. Ferguson, 2 weeks. All right, we'll be back on April 10th.
May I please report?
Yes.
What if the prosecutor and I can agree on a bond amount and share that information with you today? With that?
No, based upon the way the law has changed, I'm not allowed to do that anymore. Talk to the legislatures, people.
Right now.
Thank you.
No,
Raul
I'm-
Reyes.
This case. I've had it. I cannot represent him anymore.
All right, Norma, you need to have someone from MAC come down. All right,
He needs to either represent himself or hire somebody, because I'm not going to be somebody's punching bag. I've been doing this too long to be yelled and screamed at and treated like I was a indentured servant. And so,
all right, we'll have them come. Just give us a moment.
thank you.
You're welcome. Norma, on Aiden Silva. Is he in custody? All right, thank you. Yes, I do. Who's here on Christian Segovia? Court is calling 2023 CR 0292, State of Texas versus Christian Segovia. Can I have parties announced for the record for the state?
Debbie Cruz on behalf of the state, Your Honor.
Defense?
Christian on behalf of the defendants.
All right, and are you Mr. Christian Segovia? Counsel, have you received all the discovery in this case and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Segovia, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that document with your attorney? Did you understand it and did you sign it? Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We did.
State, are you proceeding on the indictment as presented
We are, Your Honor.
on all counts?
Yes, Your Honor.
And are all counts aggravated robbery?
They are, Your Honor.
All right. Mr. Segovia, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Do you understand you're charged with the offense of aggravated robbery in count 1, 2, and 3?
Yes, ma'am.
That is, the range of punishment is anywhere from 5 to 99 years or life in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargaining agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if at any time your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to $10,000 fine in each count? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
he does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is.
Mr. Segovia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state is proceeding on all counts. There's $1,000 fine. State recommends deferred adjudication. There is to be restitution to Damian Ortiz, Alan Hernandez of $849.99. Jathan, Jathyn Cantu. And you are to plea as a party with Joe Vitala, Vitela. And there's to be no contact with Damian Ortiz, Alan Hernandez, or Jathan Cantu. Did you understand that to be the plea? Defense,
Yes.
state.
Yes, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There have been motions filed, Judge, but no negative votes.
Outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 10 years. There be a TAP evaluation and 120 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offense as charged in count 1, how do you plead? Guilty, not guilty, or no contest?
No contract.
And in count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
And count 3, how do you plead? Guilty, not guilty, or no contest? State any evidence.
At this time, state introduces state's exhibit number 1 and all of its attachments.
We have no objections.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. You may continue to confer. All right, after reviewing states exhibits one and attachments, the court will find there is sufficient evidence to find you guilty in count 1, 2, and 3. Are you proceeding with sentencing?
We'd like to, Judge, since the state is recommending, or we'd like to. Ask the court to follow that.
Why should I follow this plea?
Judge, he wasn't the one with the knife. He doesn't have any priors. He is extremely young. He has, I think he graduated from high school, has he not, Mr. Segovia? And this was just a completely stupid thing that they did on a whim at McDonald's one afternoon. It was just completely stupid. And Mr. Segovia and I have talked at length about a deferred adjudication and what that entails. And he assures me that this stupidity is done, that he has no problem doing whatever the court requests of him on this probation, and that he feels confident that he can make it to its successful completion.
All right, why shouldn't I send you to prison?
So I do what I'm supposed to.
Well, I mean, yes,
Get closer to me.
I mean, I'm gonna do what I'm supposed to. And then I wanna go home and be a father, and then I got a baby on the way.
I'm doing what I'm supposed to, and I'm not on probation. You see, everybody who's in the well of this court, including your attorney, she's doing what she's supposed to do. Ms. Christian, are you on probation?
Not today, Judge.
Yeah, not today. Yeah, we're not on probation, and we're not going to McDonald's taking people's property and then coming to the court saying, I have a baby on the way. Did you just have a baby on the way today, or has this baby been on the way for a while?
It's been on the way. My wife is due in 8 weeks.
So was this baby on the way when this happened? So why were you not at home with your wife since she has a baby that's on the way?
And she wanted to go out to eat.
And did she go with you?
Yes, ma'am.
All right, so you're with your wife in doing this, which means that neither one of you should probably be raising a child because you're making dumb decisions, right? And you're making decisions that impact the lives of your baby, that impact your ability to get a job, that impacts your wife's ability to have employment. People need to stop just out here having children and, oh, I'm a father, or oh, I'm a mother. Just having a baby doesn't make you a father or mother. Just because people are living together, they don't make that person your wife or your husband. So are you all legally married? Did you come to the courthouse and fill out paperwork?
No, we're planning on getting married.
So that's not your wife. That's somebody that you're living with and y'all decided, or maybe you didn't decide, she just ends up pregnant. Who are you all living with?
Sister.
All right, so you and the person you're living with just are bringing in another mouth for your sister to feed. Are you working?
Yes, ma'am.
Doing what? Not at McDonald's, I hope.
No, section.
All right, and your girlfriend who's having your baby, what does she do for a living?
Or she works at Segovia.
And what is her name?
Absolutely. ABC Active Martinez.
Usually when I worked in CPS court, you know how they spelled absentee?
Yes, I do.
ABCDE. But now they've done absentee. Okay. Where are your parents?
My grandma, she stays with my dad.
But I mean, are they in your life? Where's your mom, your dad?
I don't know.
Why not?
Well, my mom gave me away to my dad, and my dad gave me away to my grandma.
Okay. And has Child Protective Services been involved in your life? Do you have any other children other than this baby that's on the way? And how old are you?
Everyone?
All right, and does your sister want you living with her?
Yes, ma'am.
Has she said that?
Yes, ma'am.
Does she have children?
Yes, ma'am.
How many children does she have?
2.
And what are their ages?
Have to be 3 and a 1-year-old.
And does she have a boyfriend or somebody else who's living with her? State? Is there a reason I should follow this agreement other than the fact that he's young and making decisions that don't take into consideration other people?
Your Honor, one of the major considerations in extending the deferred was that he was going to be as a party and cooperate against the co-defendant, Your Honor, Joe Vincent Vitello. That was one of the biggest considerations we took into account, and we just did speak with the complaining witnesses on it. And
Okay,
that's their understanding.
all right. And the complaining witnesses are in agreement with this offer?
If he cooperates as a cooperates against the co-defendant, Your Honor.
All right. And when is the trial coming up for Mr. Joe Vincent?
Those
Vitello?
cases are still currently pending indictment, Your Honor.
When is that going to happen? Does anyone have an idea about that?
No, Your Honor, I'm not at this time.
All right, this is what the court is going to do. Court is not going to make a ruling on his application. I'm going to ask for a TAP evaluation and PSI. It can be done while he's out of custody. I'm going to want him on GPS, and it'll be partial. He'll be allowed to work. And that is it. You go to work, and then if the mother of your future child is about to go in labor or something, counsel, just let the court know. And of course, I will allow him to do that. And while he's on GPS, he's going to do, you're going to do UAs for the court. You understand?
Yes, ma'am.
All right, so we're going to set this, Norman, let's do this in 45 days. Oh, I'm sorry, when is the PSI date? Because it's longer than that, right?
Yes.
What?
It's before.
All right. So we're going to set this for May 4th. And we're going to see where you are.
Yes, ma'am.
And whether or not I follow this agreement, a majority of this is going to depend on you. If you step out of line with my conditions, then I will consider whether or not I should follow this. If you're on the straight and narrow, maybe I'll follow it. Do you understand?
Yes, ma'am.
So the next thing that happens on May 4th is completely up to you.
Yes, ma'am.
So we're going to set it for PSI and TAP. And I'm going to ask for GPS, waive fees. And if there's an issue with him making bond, let the court know, and the court will consider a bond reduction. And-
I'm quite certain that that is the case.
Okay.
I don't know if the court needs a formal motion, you may.
Yeah, if you can give me a formal motion on that,
I
and
would
if
be
you
happy
will
to do
add
so.
in that formal motion that the state has
This is
agreed
the
to him to have
circumstance, sure.
deferred, yes. All right, and so we're gonna do UAs, and it'll be regular UAs. All right, we'll see you at that time.
Thank you, Judge. May we excuse?
Yes. Oh, Ms. Ferguson, make sure he gets a reset form.
Yes, ma'am.
That's done. All right, everyone's sitting here. We're getting ready to bring a jury in. Yes, who do you have?
Judah Castilla.
Right?
Judge, may I get a reset for a plea, please?
Okay, where is Judah Castilla?
Right here, Your Honor.
All right. All right, state, Mr. Castillo,
Yes, sorry.
they're saying that they're going to enter a plea.
Okay.
And Mr. Cisneros, is that a plea with him to, are you asking for a reset so that he can be sentenced at a different time, or?
No, Your Honor, I'm asking for a plea because I've been here all morning and I've had like 20 phone calls and I have a lot of things.
No, but I mean, do you guys have the paperwork ready?
No, ma'am, no, ma'am. We just came to an agreement.
Oh, you just came to an agreement?
Yes, ma'am.
All right, then I will have you all come back on Thursday.
Thursday, this Thursday?
Yes.
30th?
Yes.
Thank you, Your Honor.
All right, Ms. Fergus, can you give a reset to on Castillo for Thursday for a plea?
Did you ever hear from the math?
Norma, what's the update on Mac?
I called him. I gave him the information. I don't know if they're coming by.
All right, bring me all the files that are remaining that we're still have on the docket, and let me call those. Thank you. Thank you. So that's all that's remaining?
Oh, one page.
Okay. Thank you.
And I think that there's another plea as well. The first one.
What, Annabelle? No, I have it. All right, here you go. All right, Jalen Collins. All right, Collins, come on down.
Not the middle.
You're on the side, Mr. Cox.
Okay, on the side.
All right, are you proceeding with this motion to revoke?
Yes, Your Honor. We're gonna need a contested hearing.
All right. Ms. Ferguson, I need a contested hearing on Mr. Jalen Collins. You want 17th or 18th? All right, we're coming back on April 17th for your contested hearing. All right, and what is happening with the new case? Do you have all of the discovery?
Find everything on new case, Judge, you know, I need to continue to review just make sure I have everything.
I'm sorry, what?
I need some time on the new case.
All right, we'll see you back on the 17th. All right, thank you. Lucian Jesus Fraga. All right, where's Anita Garza on Fraga?
I've been contacting your judge.
All right, recall it for tomorrow. And tell Mac they need to be here tomorrow because she's not here.
On both cases, judge?
Just 1 second. I'll get to that one. Jose Garcia. All right, Norma, recall that for tomorrow. All right, who's the attorney on Leonardo Rosales?
That is, I met Judge, he actually emailed me, saying he was in South America, had some family issues up there. He said he filed a motion for continuance.
All right, where's the motion for continuance?
It's in Ecuador.
Can you sit down for a second?
Oh,
Yes.
oh.
Yes, you can have a seat. Richard Thomas. Who's the attorney on Richard Thomas?
Or is it the hallway?
All right, tell him to come in. Richard, what is your client's name?
Raul Reyes?
All right, Raul Reyes, come on down.
Good afternoon.
Good afternoon. What's your issue?
I have a conflict of interest with Mr. Garcia. I wrote to the state bar last week because he hasn't, I guess we can't come to an agreement. He hasn't filed.
Now, here's the thing.
Sorry.
This is what people always assume. People always think that they're qualified to be an attorney. You know why? And I discovered this from my time as a defense attorney and a prosecutor. They think that they can be attorney because they think all we do is talk. Now, you're about to say he didn't file some motion. Well, guess what? The state is obligated to turn over certain evidence for him. People always say, well, I want evidence that's favorable to me. The defense can file a motion asking for Brady material, but guess what? The state has to turn it over. And whether he files a motion or not, asking for them to turn over evidence that's favorable, they still have to do it. Right? Now, what I've discovered is sometimes people get made an offer. They don't like that offer. And they take that out on their attorney because the attorney is saying, hey, this is what the state is offering. But sometimes the person's like, well, I don't want that. I want something else. Your counsel cannot force the state to give you what they want. When the state makes an offer, you can think that offer is ridiculous. You can say it's ridiculous. Although I ask people not to do that because I want everybody to be kind to each other in this court. You can just say, you're not going to accept that. And then you know what? Your attorney will go to the state and say, the offer you made, he's not accepting it. Then you can say, well, I want to accept this offer, but this is what I will accept, which is called a counter offer. Then your attorney can go to the state and the state can think or say that's a ridiculous offer. But again, I encourage people not to do that because I want everybody to be kind. And they can say, I'm not going to make him that offer. Then guess what? You go to jury trial. The end. There is no being disrespectful to people. I always tell people, even if you don't like somebody, even if you don't appreciate what they're saying to you, there's no need to be disrespectful to each other. He has a job to do. He's trying to do his job. The state have their job to do. They're trying to do their job. I'm trying to do my job. The court reporter is doing her job, and everybody just want to have a nice day. So sometimes we don't get what we want, and then you have a choice to make. And your choice is either you're going to jury trial or you're not. Either you're accepting the state's offer or you're not. The state has tendered their offer, and that's their offer. And unless they decide to change it, that's the offer. And then when people have a counsel that is appointed to them, guess what? If you don't want your court appointed counsel, you can have anybody you want. You go out and hire them. I don't know why we've gotten to the point in this world where people want stuff for free and they want people to give them stuff for free. Oh, I don't like that one. You know, it's like if I go to the restaurant and they want to offer me free food and they say, you know what? You don't have any money. You're asking for free food. And I say, well, I don't want the rice that you're giving me. I want the steak and lobster. I don't want that sandwich. So this is your court-appointed attorney. He's qualified to be your court-appointed attorney. Now, if you would like to hire another attorney, you're more than welcome to do so. So are you going to hire an attorney?
That's what I would like to ask, Your Honor. I got, my bond was, I moved back.
No, we're not talking about a bond. We're talking about whether or not you want to hire an attorney.
I'd like to be able to, if I can get out and purchase one or hire
Yeah.
one.
And Your Honor, if I may, it has nothing to do with anything you have said. It has to do with personal. In the 27 years that I've been practicing, I've never been treated the way that Mr. Reyes has treated me. The names he's called me, I'm not going to help him. I'm not going to do anything further for him. It's ridiculous that he's treated me the way he's treated me, and I don't deserve to be treated the way he has treated me. So if you keep me on, I'm not going to lift one finger for him. I'm sorry. I've been doing this for 27 years. I'm old and I don't have to put up with
You're
his-
not old. Nobody's old.
Well, I'm older than I was 30 years ago. And so I don't need to put up with his shenanigans. And so he needs to either be appointed someone else that is going to put up with his, for lack of a better word, BS, or represent himself.
All right, you want to represent yourself? You want to hire an attorney?
Let's hire an attorney.
All right, we're going to go on the record. We're on the record in 2022.
Your Honor, I can't afford an attorney. If I guess I'll just represent myself.
All right, we're on the record in 2022 CR 4920, State of Texas versus Raul Reyes. The court is in receipt of a motion to withdraw. State, do you have any objections to defense counsel's motion to withdraw?
No objections, Your Honor.
Mr. Reyes, do you have any objections to his withdrawing?
No.
All right. That will be granted. Thank you.
Thank you, Judge.
May I ask a question, Your Honor?
And Mr. Reyes, we're going to recall your case in 2 weeks. Ms. Ferguson, what's the 2-week reset date?
April 10th.
All right, we're going to bring you back on April 10th. All right, thank you. We're off the record.
And is there a way I can get reconsideration on the bond that I've been paying for that was remanded? If I can get back to
No.
work.
You'll have to file a motion.
Okay.
All right, thank you. All right, then on Richard Thomas.
Did you say Richard Thomas?
Yes.
I apologize.
Oh, no problem. How long is this trial going to take?
4 days, I believe.
Approximately, Your Honor.
4 days? Okay, just give me a moment. Daniel Van Duzer.
Yes, Judge.
All right. Let me see. How long is your trial going to take?
I would.
Okay, why don't I have a file on Van Duzer?
You don't?
No, I do not. Thank you. All right, State, on Van Duzer, which one would you be going on?
Your Honor, it's Mr. Escobar's case, Your Honor. Let me just, if I could just get
Sure.
a second.
All right, no problem. Do I have all the files?
Yes, you should have all of that.
Every last one? Okay.
Your Honor, I believe he did mention it was going to be the possession case.
All right, so how long are we anticipating on Van Duzer with the possession case, Ms. Christian?
Judge, we've only been informed on the RT case. We have not conferred on.
All right, can you all please confirm the possession case? I have patience in my pocket. I'm taking it out. All right, can I have the stamp? And can I have the parties come up on Vanessa Baez? All right. And council, just have a seat. I will get with you in a moment. Thank you. Court is calling 2023 CR 1969 State of Texas versus Vanessa Baez. Can I have parties announced for the record for the state?
Mariela Encinas for the state of Texas, Your Honor.
Defense?
Joseph Upheld for the defense.
Are you Miss Baez?
Miss Bass,
Bass. All right, is there one B or just?
one B, I mean, one
One
B,
A.
one S.
Okay. Counsel, have you received all the discovery in this case and did you review it with your client?
I believe I have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Bass, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
You do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right, Ms. Bass, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of driving while intoxicated with a child
Yes, ma'am.
15, under 15? Did you understand?
Yes.
All right, that's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against him?
I do so, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe so.
Ms. Bass, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargaining page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargaining agreement, punishment is to be assessed at 180 days in the state jail facility. There's a $500 fine, no application for deferred adjudication. State recommends community supervision, and there's to be restitution to Carlos Tovar and ignition interlock for half the term. Did you understand that to be the plea? Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only things that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There have not, Your Honor.
Next, I'm showing you outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There'll be a TAP evaluation, 150 hours community service restitution, 1 year driver's license suspension, DWI intervention, and VIP. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plea to count 1, paragraph A, B, and C?
Be guilty.
State, any evidence support the defendant's plea?
Yes, Your Honor. State offers state exhibit 1 in all attachments.
We've reviewed those, Your Honor, with the defense, with the defendant, Ms. Baez, and we have no objections.
All right, you may be excused. Ms. Bass, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. Someone's dimming the lights. That's okay. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty in count 1, paragraph A, B, and C. And the court will find you guilty. Are you proceeding with sentencing?
With permission of the court, Your Honor, yes.
Anything you wish to say on behalf of your client?
If it pleases the court, Ms. Baez has readily accepted responsibility for her actions on that day as not just evidenced by her plea of guilty, but this is the first setting that we're on. And she actually, as the court is aware, turned herself in yesterday due to a misunderstanding and miscommunication of her court date a few months back. But she wanted to take care of this as soon as possible, thereby also showing her admittance of guilt and her acceptance of the responsibility for her actions. With respect to Ms. Baez herself, she's been married for 6 years. They have 4 children, ages 15 now, just turned 15, 9, and twins that are 6. She is currently employed at Spring Hill Marriott, and she has been for almost a year in the housekeeping division. There she lives with her husband and her 4 children. Due to the certain financial limitations that she has, she is on Medicaid for the children and some financial assistance, mainly food stamps. And so we're going to respectfully request the court to not only follow the plea bargain, but when you do, Your Honor, to assess the minimum reporting fees, minimum supervisory fees, as well as follow the $500 fine. And since restitution may be involved, she did have insurance on the vehicle. If there's any restitution that's involved, that's important, we believe. And so if you could probate some of that fine as well. She does realize and recognize it is already low considering what it could be. With respect to that, Judge, we do ask you to follow the plea bargain.
All right, anything you wish to say, Ms. Bass?
I truly apologize for my actions. I know it wasn't right and I messed up and I'm trying to hold responsibility for what I've done. And I just, if you just give me a chance, I really don't want to be out of my children's lives. Like, I know what matters and they're my priority. I should have known this 6 months ago, but there's no excuse, there's not. I really, really am sorry, like, I made a mistake.
No, not a mistake. I always tell people a choice.
A choice, I made a wrong choice.
Yes. Because what I've discovered, and I always tell people this, my statistics professor will be upset with me because I haven't done a study. But based upon what I've seen, usually the person who's driving intoxicated, when they get in an accident, they're just fine. Usually it's their passengers who get killed. In this case, it could have been your children. Usually it's some grandmother who's just out trying to enjoy her golden years. I put myself in the golden years category because I'm in the twilight of my life. But usually that's who it is. Somebody who's just trying to enjoy their life. And I don't know why it is in San Antonio and other places. Guess what? If you're going to drink, just have a designated driver. I don't drink. I think alcohol doesn't taste good. That's why I don't drink. But I was always a designated driver for people. You know, because of that, I got free Sprite with lime from everybody because they're like, Stephanie's the designated driver. And I was fine with that. Have a designated driver. Or you know what? Take the VIA bus. I'm going to go drink. I'm taking the VIA bus. Or either drink at your house. There's no need to get behind the wheel because things can go badly pretty quickly. You understand?
Yes, I understand and you are correct.
Okay. All right, this is what I'm gonna do. I'm gonna sentence you to a $500 fine that will be probated, 180 days in the state jail facility, suspended and probated for 2 years, proof of employment within 15 days, no employment as a home health care provider with minors, restitution, if any, to Carlos Tovar. If for any reason the restitution appears that it's not what it should be, you can always approach the court. 150 hours of community service restitution. I'm going to require parenting classes. Once you complete the parenting classes, that will satisfy your 150 hours community service restitution. I'm going to want 90 sober meetings in 90 days, 1 year Texas driver's license suspension, DWI intervention, VIP, regular reporting by Zoom or in person. I'm going to want a TAP evaluation. If the TAP recommends inpatient treatment, we'll start with intensive outpatient treatment. If it recommends intensive outpatient treatment, we're going to start with supportive outpatient treatment. I'm going to want ignition interlock for half the term. We'll do field visits one time for 2 months. If there are no issues with field visits, then probation, you can discontinue them if you think it's appropriate. Probation, is there anything else she needs? Is there anything else you need from the court to be successful? All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand? If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Thank you for dressing appropriately for court. And thank you. You were taken into custody yesterday. You were released and you still made it to court on time. I appreciate that. And thank you for your honesty.
Judge, we may need to go back and one more thing. It has to do with the vehicle. She doesn't have a vehicle.
All right, so if she does not have a vehicle, we're back on the record. You will need to provide an affidavit of non-driving. So that means that you cannot drive any vehicle. And probation, I want it checked to make sure that there are no vehicles at that home. And then if that is the case, then the court will order a mobile device. And probation, she can do whichever mobile device, which is the least expensive one.
I believe she's currently on Scram, Your Honor.
Okay.
And she's been riding the bus since she lacked the funds to get the vehicle out of the impound. And I do realize, and I've explained to her that if she does get a vehicle, then she's going to have to come back to the court or have ignition placed on that vehicle at that time, and that term has not expired yet.
Okay. All right, thank you. I used to ride the VIA bus. It is nice, right?
It's peaceful, like, I like to catch the bus and then I go through my little route and get my breakfast, go to work. I like it.
All right, thank you.
Thank you.
May I excuse you, Your Honor?
You're welcome.
Thank you,
Yes,
Judge.
you may be excused. And probation, that'll still be for half the term.
Yes.
Yes. Okay. Okay. All right, thank you. You have been working.
Part of the job.
Yeah. There you go. Thank you. You're welcome. Yes. All right, and is there any other pleas left? Or no? Okay.
I'm sorry. Max is here.
Hi.
It's not on
Okay.
the record. And just want to let you know, we got, thanks for giving us the notice about the issue. We're gonna have somebody appointed today, so.
Okay, so,
Moving on forward.
all right, so, and when do we have that coming back, Norma?
4:10.
All right, so,
So we'll try to do our best to have somebody ready and raring to go, so.
okay, awesome.
And Your Honor, we appreciate it. We're gonna let our defense attorneys know too. It's like a good moment, so we can ask them. They don't have to bring this to you anymore. They can come to us.
Okay,
That way you don't have to deal with it. So that's what I wanted to let you know.
all right, thank you
Thanks,
so
Judge.
much. I appreciate it. And thanks for coming down. Okay, so that's done. All right, so the person who's filing a motion for continuance on Leonardo Ruiz, who is that?
And then Judge, that's what I tell you, South America.
All right, so why isn't this notarized?
I don't know. I want to say I'm not the secretary.
All right, so if you can let his office know. If you can let his office know that motions for continuances need to be notarized. That's not my rule. That's, if they want to change the law on that, then they need to do that. So Mr. Ruiz, Norma, have him come back tomorrow. I think his name is Leonardo Rosales Ruiz. So it's just listed on the docket as Leonardo Rosales. I think that's the same person, correct? All right, that's done. Oops. And I don't have a rubber band. All right, thank you. And then Mario Tovar Hernandez.
That's a new Garza. Get a hold of her.
Oh, and did you let the MAC know?
No, not on the Spanish speakers.
Yes, put it on for tomorrow. Norma, can you give that to Deputy Laura? Is that correct, Norma? All right, so everyone can know, I received a notice. This is what happened with our jurors. So our jurors one day were released late after 5 o'clock. So they're released at 5:30. And I always tell jurors, when you're going out the parking garage, just tell them that the central jury room is closed, that your parking can still be validated, and you will receive $3. That will be the cost of parking. So the jury I had here, they told them that and they still made them pay full price. So when they came in the next day, I told them, you know what, you shouldn't have paid you shouldn't have paid full price. So you should be able to get free parking for today because you paid full price. So someone who works at the parking garage informed me, there is no free parking. Yes, but you should not have paid, you should not have charged them full price. So now they're giving out this notice to all jurors, important notice, parking is not free. But what happens if you are inappropriately charged for full price when you should not have been? Bureaucracy, right? So there you go. So it's, you can't, but I'm going to do the best I can because they shouldn't have to pay. All right, so Jalen Collins, that's done, correct?
That's correct.
Yes, that's been separate contested.
Okay. And then the next case we have is Juan Antonio Garcia Sanchez. All right, so what's happening with this case?
Your Honor, the state's ready.
Are you ready?
Well, your judge, I've been under the weather for the past week. So
Well, have you filed a motion for continuance?
I haven't because I was that sick.
Okay, well, you need to file a motion for
I
continuance.
will,
I'm going to recall it for tomorrow. You need to be here tomorrow.
okay,
And you need to file the motion for continuance and then the court will consider it.
all right.
But please I know you always do, but please make sure it's notarized.
I always notarize my.
I know you do,
and
but
I was laughing when you were saying mention. Because everybody's knowledge that that's the case.
I know you do, but some people don't. So I'm just putting that out there. Ms. Ferguson, can you give them a reset form for tomorrow? And your client was late
This morning or this afternoon?
this morning.
Okay, that was- Said that he called me, but I couldn't answer and because there was a bottleneck.
Okay. All right, just no more lateness, all right? So we'll see you tomorrow at 9 a.m. And then we have Mr. Melvin Jones. All right, Mr. Porter, on your case, I know that you are ready for trial. I know the state is ready for trial. Mr. Jones?
Yes,
The only issue, Mr. Jones, is I think your trial is going to take us past Friday. Is that correct, Mr. Porter?
that's correct.
All right, so here's the issue or the quandary. I actually have a case that's specially set and we're going to start jury. Are we starting jury selection on that on Friday?
Yes, sir.
And so that case is much older than yours. And so I had to actually have a jury ordered for Friday. So I'm not going to be able to do your case today. Because how long do you think yours will last, Mr. Porter?
Depends on. That's pretty loud here.
Mhm.
It depends on what happens in the case of chief judge. That issue is simply the amount of cases the state's gonna want to prove up and punishment should go that way.
All right,
So I would say at least.
all right, that's a week. So which case would you all would be proceeding on? All
It would be a drug case, Judge.
right, do you know,
The 2022 CR.
the 8529?
May I say something?
Yes.
I know that
Well, let me ask you, before you say something, have you asked your, or told your counsel what you want to say?
Yes, Your Honor, 852.
Okay.
You can ask the judge that. I've already told you what the.
Yes.
Well, my concern was that this case that they talking about going trial on is a 9-month-old case, and I have 3 other charges that's 3 years old that I've been wanting to try to take care of and get out the way, because this newer case is really, I don't know, I haven't been able to go over with my attorney because the last time.
Oh, well, this is what we're gonna do. State, do you have your file?
Your Honor, I can bring it down.
All right, so the state has their file. If you want to go over something with your attorney, you can. We're here.
It's kind of, I mean, because I.
All right, if you, okay, we're gonna take care of that. Can you bring the file down? And Mr. Porter, I know your work, so
Well, I'm sorry, Judge.
I said, I know your work. So they're gonna bring the file down for you to look at, Mr. Jones. All right, and then we have Mr. Thomas, Richard Thomas. That's you, right? And see, if I have to say Chavez, I don't say it correctly. All right, so on this case, how long are you all expecting this trial?
4 days.
4 days? All right, so I actually have a jury trial that's sort of specially set on Friday. So I'm assuming you all will not be done on Friday. All right. So is there a lot of videos in this?
Not a lot of videos, but there are approximately 4 to 5 witnesses per side.
Okay. All right. So are there any motions that need to be heard?
Yes, several pre-trial motions that have been filed.
All right. So this is what we're going to do. I'm going to bring you guys back for pretrial motions unless you're ready to go on your pretrial motions now. All right. So if you all can discuss the pretrial motions, see what you can agree on, what you can't agree on, I'll make a decision on that. And I'll have the clerk to pull the pretrial motions for me.
Would that include the eliminations? Because I have not received anything from the state.
Yes, it'll include everything. All right. And everyone, I'm just going to take a brief recess. All right. Can you have your client come up, please? And let me pull the motions on my end. That's another spam. Oh,
AT&T.
yes. All right, I am so sorry. I do not have your motions with me. All right.
They were filed last year, Your Honor, 13 June 2020.
Yeah, and they didn't make it to this file, so we're gonna get them. We're gonna take care of it today. Or if you want, you have copies of them?
I do.
If you want to, Norma, instead of pulling it, because those are file stamped, correct?
No, these are not copies. These are my copies.
Okay, if you'll,
This is one of them. There's several.
they'll make a copy and then we'll take them up. Thanks for your patience and thanks for dressing appropriately for court.
You want me to give you the order that I have or?
Oh, yeah, whichever, if you would go at the back and make a copy of that, because is that the order you're gonna go in?
This, yeah, this.
Yeah, if you'll
They're
make,
all attached to the motions, but I just got my own.
okay. However you want to do it.
This boss.
My goal is to try to make people's job as easy as possible, as far as, not making things difficult. If people want to go in a certain order on their motions, I'm fine with that.
As he's looking, there's one motion that I think I know. We're not gonna be able to take care of it, which is the motion to suppress
Yes.
the price statement. But I think that we have a disagreement and when I have a motion to suppress a confession, it's an alleged confession.
Mhm.
It's based solely on a polygraph test. And I think the state says that they believe that they need a witness, but conferring with the state, they're not gonna have that witness. So
Well, here's my question. Are you all seeking to bring in polygraph results or what was said at the polygraph?
What was said at the polygraph,
Okay.
statements made to the polygraph examiner.
the problem, Your Honor, is that confession that my client allegedly made is based solely on that polygraph itself. So and during the polygraphs himself, he testified that my Christ is truthful. Yet he tells the social worker or the lady, which she's gonna come, that, oh yeah, he made a confession. And so that's what made her come back to him and says, look, we gotta take your kids away unless you confess. That's what led to a confession. So that because of that, you're going to make a motion to be heard before the trial to suppress that alleged confession.
All right, I'll hear. I'll hear your motion. If there are going to be witnesses who come, just let Ms. Ferguson know what date and we'll do it probably maybe a Monday afternoon.
I have a question on, is this case possibly be able to be specially set? We've been coming at this for almost a year now.
Yeah, I don't do special settings because if something ends up happening with the special setting case, right, then we do nothing.
With all due respect, I just heard you say that you had a special.
No, it's not specially set it. The jury is coming in on Friday because usually we have jurors come in on Tuesday. So we're actually have a jury panel come in on Friday. And it's special in the fact that we don't normally have jurors available on Friday. So we had to order jurors this week for Friday. So that's what I mean by special. No problem. But otherwise, I don't.
Judge, I need to go to the back here. Pick up the other one. Happened to the center.
All right, so the two motions, she's going back to get another motion. The two motions I have before me now are the motion in limine, and I have the motion for notice of state's intention to use evidence of extraneous offenses at trial.
So as a 404B,
Okay,
609, 803, 804, 902.
so are you, before because we're not on the record yet. So are you okay with us proceeding with this? And then Ms. Ferguson will bring the other motion to me?
Yes.
So of these two, which one do you want to proceed on first?
Whatever pleases the court.
Okay, thank you. Court is calling 2021 CR 4470, State of Texas versus Richard Anthony Thomas. Can I have parties announced for the record for the state?
Ruben Herrera for the state.
Defense?
On behalf of the defendant.
And are you Mr. Thomas?
Yes.
All right, the court is in receipt of pretrial motions from defense counsel. The first motion, let's start with the defendant's motion in limine. Defense? Is this agreed to or no?
Affirmative say that they have a question on one particular item. Other than that, they're in agreement, and I believe the item is. Prosecutor, I'm sorry.
It is as to 19A, Judge, of the prosecutor not to express a personal opinion regarding the credibility of the witnesses, the strength of the evidence, the guilt of the defendant, or the appropriate punishment. Prohibited in argument includes, but is not limited to, the following. Subsection A states that the prosecutor believes the defendant is guilty. We're seeking clarification whether or not whether this is limited to personal opinion. For example, saying, I believe personally that this defendant is guilty, or whether in our closing remarks, as is typical of the state, that the state asked for the jury to find the defendant guilty.
So, Your Honor, this particular subsection 19 is very specific in relation to the credibility of the witness, as the jurors are the ones to establish the credibility, not the prosecutors to say, well, I believe that testimony is to be false. And that's what the case is Villalobos State, I-68, Southwest Second 134. This is a Texas criminal appeals case in 1978 that stated that type of argument from the prosecutors actually prohibited. So as a cautionary measure, to put it in there, Your Honor.
All right, so you're just asking that the state or the prosecutor not express a personal opinion as to whether or not the defendant is guilty. Is that correct?
The credibility of the witness, Your Honor.
Well, but we're starting with A first. A says that the prosecutor believes the defendant is guilty.
Oh, yeah, on that subsection, yes, Your Honor.
So with regards to that, you're asking that the state not be allowed to say that they personally believe the defendant is guilty.
On a personal level.
All right, so I'm interpreting that to mean that state, you can say the defendant is guilty and this is why, but not saying I personally believe.
My own, I have the gut feeling that he's guilty, that type of.
The state's in agreement with that, but
Okay.
we just wanted to clarify and make sure that we're correct on that.
All right, so that it's understood. I think it's understood from your intro paragraph where it says personal opinion.
Yes, Your Honor.
But what I'll put, if there's no objection, in A where it says that the prosecutor believes the defendant is guilty, I will put that the prosecutor personally believes. Are you okay with that, counsel? Okay.
Other than that, Your Honor, the prosecutor has agreed with all.
Well, counsel, let's do this. All right, with regards to number one,
State's in agreement, Your Honor.
all right, when you say bring weapons into the court, do you mean just in general?
So I had an encounter, Your Honor, that the prosecutor itself, they're felony prosecutors, they're entitled to have it. But they brought it to the court and they showed the jury. I was telling the prosecutor, he said, oh, based on personal experience. And they showed it to I carry this gun because I'm a fellow prosecutor and most people are guilty, that type of behavior.
Okay, all right, don't bring any guns in this courtroom. Okay. Oh, wow, I have to ask, which county was that?
It's a Vida County, Your Honor.
Okay. All right, so number one is agreed. Number two, are you displaying your badges?
I have badge, Judge, but for the purpose of the trial, we can take that off.
Judge, all of this comes again from a personal experience,
I'm-
showing the jurors, look, this badge don't lie. Because of this, you have to believe me when I tell you that this person is that type of behavior again, Your Honor.
All right, but I mean, he is
No, not-
allowed to wear his lapel pin.
Come on.
Okay,
And I
All
do
right.
apologize for this has been personal experiences at trial.
oh no, I'm here.
Protect the record.
No, I appreciate that. All right, number three, asking leading questions of prosecution witnesses on direct examination. The only thing about that is you are allowed to ask leading questions for introductory purposes,
I just gonna.
both
make
sides.
An quotation for the record is so it's clear. Are you using your ADA experience of years? Not only you've seen this before, is that what we're doing? Because it's not gonna be here all day. I just
No.
wanna make sure that we know that the state has agreed all of them.
No. I'm using my defense attorney hat, my prosecutor hat, my judge hat. I mean, I've done both sides, but if this is going to be agreement to this,
So on the reg examination,
Yeah.
you cannot ask leading question. That's an axiom of law. It's a maximum of law. They already know. Can't lead. You witness, now you can lead as a reg. I mean, opposing witness for that.
no, actually you are allowed to lead on direct for under two circumstances. And let me tell
I
you,
was asking you
Yeah.
to come from the
Yeah.
ADA experience, Your Honor.
yeah, but
I just don't know if he knows the exceptions.
no. Oh, I think both sides know the exception. The exception is if it's introductory. But not, of course, you can't normally lead with regards to the facts of the case or what you think the facts are. But you are allowed to ask leading questions on direct examination if a witness is determined to be hostile. So my question for both sides, because I want to be clear when I make my rulings, I know there are exceptions to this, but you all are just doing blanket statements. Nobody is allowed to ask leading questions, which interferes with the court's purview as far as, for example, if a witness were determined to be hostile, or if it's for introductory, you all, by agreeing to this, you are saying, Judge, you're not in charge of making rulings. The people who are making the rulings
That's not the intention.
are both parties.
That's
So,
not the intention. I understand that before I can attack a witness as hostile, I have to ask permission. You understand that now? And this is just things that have happened in the past in my own practice, and I put them in there now.
Yeah.
Are they broad? They are, but they're not in any way, shape, or form to limit the scope of the court.
Okay.
Not whatsoever.
no, I understand, but I want you all to know what you're agreeing to, because if you're agreeing that nobody can ask leading questions on direct examination, then that is telling the court, if somebody is asking questions on direct examination and it's leading, you all have agreed they're not allowed to do that. And there's no caveat that's listed here.
And obviously, Judge, we are agreeing to the fact that we cannot lead as to any of the facts that we're eliciting from any of the witnesses. But I mean, we would argue that for purposes of establishing background experience, anything like that for experts, that we'd be allowed to lead any of the witnesses on direct examination.
All right.
For that.
With regards to number 3, because I think it's entering the court's purview and my role and my authority. With regards to number 3, you all will have to approach and object if there's an issue. Okay. She's just making sure I have the complete motion because she went back and printed out something to add to it. Okay, all right, thank
There
you.
are 29 sections. Yes, I'm sorry.
No problem. So number 4, that's agreed to, correct?
Yes, sir.
And again, this comes from my personal experience.
Oh, no, I understand. And I'm not-
Judge Graham, I don't know if you remember her.
And counsel, I'm not holding this against either party. Number 5. Throwing pencils, chalk, bouncing balls.
We'll agree to that, Judge.
Okay, that's agreed. Number 6. Again, with regards to rule 6.26, you all are going to have to approach for that, because what I can tell you, counsel, is in this court, I require attorneys to remain seated because it's easier for me to hear and it's easier for the microphones to pick up. And if anybody wants to approach, you can just ask to approach.
Yeah.
So on that one, with regards to 6, just approach if there's an issue. Yes. And honestly, with regards to examination, if you want to approach the witness, all you have to do is, Your Honor, may we approach? And I always allow it.
I have seen prosecutors stand up and just approach and be like, what's happening?
Oh, yeah. Oh, and then now 6B. Yes,
Yes.
evidence will have to be admitted.
Yes.
So 6B agreed. 7. Are you all agreed on 7?
Yes, Your Honor.
I believe we're in agreement, all of them except that one.
Okay. So you're in agreement to 8? State?
Yes, Your Honor. I don't believe it's gonna be an issue in this case, but.
All right, number 9, you all need to approach. 10. All right, 10 and 9 are together, is that correct? All right, just approach. Number 11.
This is based on the 404B and all the other motions that we already. We had an agreement, but you haven't heard of it yet.
All right, just one moment. We're off the record. So with regards to Miss Bishop, is the MAC sending someone?
Well, the Mac talked to him and said he was here in Bill. Then he texted me that he took off to Del Rio.
No, call the MAC and tell them that she needs another attorney. And so tell them she needs an attorney today. All right,
Just for efficiency, 11, 12, 13, 14. Are all in relation to the 404B, 609, 802, and the other ones that we have not heard yet.
all right, so number 11, 12. Okay, number 11, let's start with 11. Number 11, you all will have to make your objections and approach. And of course, before you talk about any extraneous offenses, I don't even know if there are extraneous offenses, but before you do, before you approach a witness or ask a question to get into any of that, you'll have to approach.
I'm sorry, just for clarification. Here we are, I filed that 404B one time ago. We're about to go to trial, and I have not received any. So I don't think that there should be.
Oh, no, if they don't have any 404, with regards to the 404B, if there is any, it depends on what it is. But and whether or not it comes in, I don't know. I don't know anything about your case, but what I do know is number 11, I can't weigh anything under 403 because I don't know what it is. Now, whether or not they're allowed to get into extraneous offenses, again, they would have to approach and counsel. If need be, I will let the jury go outside. And if you want to put on the record, I haven't received notice, then that's something that I will take up at that time.
The state has been put on notice that we're requesting any extraneous offenses, and so right now, we don't have any.
Okay. All right, so number 11, you all are going to have to approach on that one. And state, before anything is put before the jury, you'll have to approach before you ask any questions about that, you'll have to approach.
Yes.
All right, number 13. I'm sorry, number 12. All right, again, you all have to approach. I don't know what your extraneous is about, or if there is extraneous.
Guess that's the notice that I'm giving we have not been given any notice of any extraneous offenses whatsoever. I believe the rule allows me to, if they have not been given notice before, they cannot come back now at the 11 hours, and, oh yeah, by the way, we have something. That's not permissible under the rules. That's what this limit is. They have to give me at least 15 days or 10 days before trial, but 30 days notice at least.
State, is there any 404B issues?
I thought I'm aware of the judge.
All right, so y'all need to approach on that. All right, and number 13. You're asking to approach on extraneous offenses. Yes. 13, is that agreed to?
Yes, Your Honor.
All right, number 14, the court can't make a decision on that until the court hears it. So number 14 isn't right for the court to hear. Number 15. All right, number 15 is not right. Just, you'll have to approach. 16. All right, no derogatory referring to the defendant by derogatory names. You're in agreement?
Of course, we're gonna do.
All right, number 17. All right, you'll have to approach on that. That is agreed. You all are asking to approach before you get into that?
Yes, ma'am.
All right, number 18, that's agreed to?
Yes.
Number 19. We already did 19.
State's in agreement with 19.
We did 19 and we did 19A. And the court added personally believes. B, that's agreed, correct?
Yes.
C,
State-
agreed. D,
State is in agreement with B.
E,
State is in agreement with E.
F,
State is in agreement with F.
G,
State agrees to G.
H,
State agrees to H.
I,
State agrees to I.
J,
State agrees to J.
K,
And state agrees to K.
all right, 20. Not referring to the defendant by any other name other than his given name, nickname, or not calling him names or saying he's less than human. Is that correct? Defense?
That is correct.
And the state is in agreement with 20, Judge.
Okay, A, are you agreed?
Yes.
B, you're in agreed?
Yes, Your Honor.
C, are you agreed?
We're in agreement.
All right, with regards to C, counsel, if someone were to say that the person who did it was Black, Hispanic, or white, or whatever, is that what you mean by that?
Race, particular race.
But what if it's a part of their identification? And this
true.
is me just asking.
So I believe when the court issue the Court of Criminal Appeals issue a ruling in relation to there's statistically speaking, when you talk on those terms to the jury, it tends to influence their decision. That's what I'm trying to prevent that. That this juror, the jury verdict, whatever that is, may be not because of his race, therefore it's not even mentioned. They can see that he, I mean,
All right, are you planning on, if, is any witness coming in to say?
I don't believe that we have identification by his actual given name. I don't believe we have any witnesses coming to identify him by his race. When reading this, we're reading this as taking into argument referencing his race. But for purposes of identification, Judge, we argue that the state can bring that in if a witness identifies him by his race. But I don't believe we have any witnesses coming to testify regarding race.
All right. So they're saying that they don't believe they have anybody. If you all think that there's going to be an issue of identification, and if race, age, height, or whatever were used, just ask to approach, and then counsel, if need be, we can have a hearing outside the presence of the jury. And D,
State's in agreement with B.
okay. 21.
The state agrees to 21, Judge.
Okay, A,
State agrees.
B,
State agrees to B.
C,
State agrees to C.
D,
State agrees to D.
E,
State agrees to E.
F,
State agrees to F.
G,
State agrees to G.
22. That's agreed to.
Yes, state agrees to 22, Judge.
A,
State agrees.
B,
State agrees.
C,
State agrees.
D,
State agrees.
E,
State agrees.
F,
State agrees.
G,
State agrees.
H,
State agrees to H.
I,
State agrees.
23.
State agrees to 23.
A,
State's in agreement.
B,
State is in agreement with B.
C,
State is in agreement.
D,
State agrees.
E,
State agrees to E.
F,
State agrees to F.
G,
State agrees to G.
H,
State agrees to H.
I,
State agrees to I.
24.
State agrees to 24.
A,
State agrees to A.
B,
State agrees to B.
C,
State agrees to C.
D,
State agrees.
E,
State agrees.
F,
State agrees.
G,
State agrees.
H,
I emailed defense, I just.
Okay.
I was just gonna make sure that we weren't forgetting anything.
Okay, all right, thank you so much. All right, H,
State agrees to H,
I,
state agrees,
J,
state agrees,
K,
state agrees,
25,
state agrees to 25,
A,
state agrees,
B,
state agrees,
C,
state agrees,
D,
states in agreement,
E,
state is in agreement with E,
F,
state agrees to F,
G,
state agrees to G,
H,
state agrees to H,
I,
state agrees to I,
J,
state agrees to J,
K,
state agrees to K,
L,
state agrees to L,
M,
state agrees to M,
N,
state agrees to N,
26.
State agrees to 26,
A,
state agrees,
B,
state agrees,
C,
state agrees,
27,
state agrees to 27,
A,
state agrees,
B,
state agrees,
C,
state agrees,
$28,
states in agreement with 28,
$29,
state agrees with 29,
all right. Defendant's motion for a notice of state's intent to use evidence of extraneous offenses at trial. That is not something that the court necessarily rules upon. He wants 404B notice. So if there's 404B notice, that's something that is not for the court to order. Either the state gives you 404B notice or either they don't. And at trial, then I'll make appropriate decisions based upon what you've been given. So the 404B issues, that's between you both. And then what will end up happening is if the state wishes to produce something that is extraneous, then the court will take that up at that time if proper notice has not been given. With regards to the motion to suppress confession, all right, with regards to the confession, that'll be carried with trial. Is there any other motions?
Those that are correct, but that's again with the problem.
Yes, that'll be carried with trial. Is there anything else?
I'm gonna say,
All right, so both sides think this will take 4 days.
Please.
All right, so Ms. Ferguson, when can we have this back for jury trial?
Judge,
Okay, April 17th.
Judge, I am on a murder trial, 226, case is especially set.
All right, is it actually gonna go?
Yes. Ms. Christian is the co-counsel on that about fully defendant, so yes, this case we've been several years, it's a murder case.
Okay. All right, Ms. Ferguson, they say that he'll be in trial. Why don't we do this? Let me ask you, counsel, if we could set it for the 17th, if something happens and your trial doesn't take place in that, then we'll go on this one, but you'll know in the morning time, right?
Well, the way they do it, they pick the jury on Friday and then we start Monday.
Ah,
But
Oh,
I'm
that's
in,
different.
I'm in the trial setting from the 14th. That's when we do all the order and everything, they come back on Monday, that's opening statements.
so you have it on the 14th.
That's on the 14th, that's when we pick the jurors.
Oh, okay, so let's keep it for the 17th, because it may, just in case something happens and it doesn't go. And then here's the thing, if you select the jury on the 14th,
They come on the
just let
14th.
us know. And he won't have to come on the 17th. We'll give you, because you have good contact information with him. All right, so what we'll do is we're going to put you for the 17th.
Okay.
If your attorney ends up in trial in the 226, by that I mean he's, in jury selection on the 14th, he'll call, let us know, and we'll give him a different date that both parties are agreeable to. And then you won't have to come in on the 17th. It'll be a different day.
Okay.
Okay?
Okay.
All right. So let's do that, Ms. Ferguson. All right. Thank you all.
Thank you.
And I would tell you, thank you for dressing appropriately for court, but you're always dressed with the beautiful colors.
Thank you for the image, Thank you.
Yes, I saw you involved in something that you were doing. It was some sort of outreach program or something that you were doing, and I saw, and I was like, I know him. So it was something good.
Try to do a good thing for the community.
Yes. So we'll be back tomorrow, guys.